Hey, welcome to the NearSight and FarSight podcast, brought to you by the investment professionals at InSight. My name's Kevin Taylor. This is the fourth in a four-part series that we've done discussing the power and the nuance of having a good, properly managed trust. We've partnered with Clint and Carlisle, attorney over at Schaefer Thomas Mays, to help navigate some of the questions and some of the possibilities that we have with these trusts. Here in the fourth part, we're going to discuss some of the habits that you should grow into when maintaining the trust, things that you should look for when updating your trust, and the timeline that's acceptable to have go by before that trust is restated and redrafted. Clinton, why don't you tell us a little bit about yourself?
My name is Clinton Carlisle. I am an attorney in Broomfield, Colorado. I've been practicing here for a number of years with the firm of Schaefer Thomas Mays. We are a small firm, 6 attorneys, that practices almost exclusively estate planning, which is wills and trusts, and administration after death. So we write the wills and the trusts, we help you create and fund them, and then we can help your beneficiaries administer them at death. Not all law firms do both sides. It's really helpful to have one that does, so they know exactly how this is going to be read, how it's going to be administered, how things are going to really work. I am a Texas native. I moved here for college, and now I live in Erie with my wife and 9-month-old son.
So much of the work that we do with clients is quarter over quarter, year over year, long-term planning. And so I'd imagine that, when dealing with trusts, there are certain milestones that say, oh, I absolutely need to go back and revisit some of these documents. But in lieu of those milestones, what is an acceptable timeline? What changes is it, and what drives that? Is it changes in the law, changes in the lifestyle, or changes in people's expectations of what happens to their assets? And how long should a trust be aged before you absolutely have to go back and revisit it?
Yeah, so for a revocable trust that we've created, let's say it's a married couple with 2 children. I, as the attorney, will try my best to write that trust so it is sufficient in almost all cases, so that if one of the children dies before you or you have another child, the trust should automatically adjust or try to adjust in a way that I would expect you to have done so yourself. But that doesn't mean that you should never update it. Commonly, people update it when they get a new child or the children age quite a bit. So we might have written this trust when your children were 5 and 7, and now they are teenagers or even in their 20s. You probably have a different opinion of how your kids can handle finances, hopefully, from when they're 7 to when they're 20. So we may have different goals as far as when children get money and what roles they might serve after your death and during life. Also, if you go through a divorce, that's commonly a time when you're going to want to look at your estate planning. Things are going to change pretty significantly. A good rule of thumb is to look at your documents at least every couple of years, not necessarily with an attorney, but look over what we prepare as a summary, which is a 5 or so page document that lays out the main terms. Take a look at that, make sure it still looks okay. Every 5 or 6 years, call the attorney is a good idea and say, hey, has anything changed in tax law or other law that makes me need to update this? Because things do change. For instance, in around 2010, lots of changes happened in tax law that made us change the way we rewrote trusts for married couples. It used to be we had to write them in a very specific tax-heavy way. And then the tax law got more flexible, and we could take out some of those tax concepts and make it more what you'd want. There's still some clients back from 2005 or 2006 or earlier that still have those old trusts because they haven't looked at them in so long. They don't even know they could make it a better, more flexible plan. So it's something you should be looking at every few years by yourself and with the help of your advisors.
So when you say pull that trust out, that causes me to think, where is the trust? Who has possession of my trust? Does the lawyer keep it? Should I keep it myself? Does the state have a copy? Who should have it, and where is it stored? What precautions should I take there?
So a trust is a legal document. There is an original somewhere that you inked on your signature. Often you have that somewhere in a safe deposit box or safe at home. The lawyer might have retained it if you asked them to. My office retains some of these documents when required or when asked. There's copies everywhere. The attorney will have a copy. You will have a copy, probably an electronic copy. I would suggest not giving children or beneficiaries copies, generally because you might make changes to that document over time, and you don't want them looking at an old copy and thinking, well, no, I was supposed to get this much money, and now I'm only getting this much money. So typically, you want to keep this a relatively secret document between you and the attorney and other advisors. You should have the original at home, and it does not get filed anywhere. In fact, a revocable trust never gets filed anywhere. A will does get filed with a probate court at death, but a revocable trust stays private. So it's only sent to your advisors, and at your death, it goes to beneficiaries, but that's it.
So there might be a lot of versions, so there's a little version control going around. What causes these living trusts? How frequently are they updated? Well, you kind of mentioned that before. But what should I do to kind of purge those old versions? What are some best practices with that?
Yeah, so whenever we update a trust as an attorney, there's two ways we can do it. One is with a simple amendment that just changes one or two paragraphs, and one is with what's called an amended and restated, so where we actually rewrite the whole trust. If you're going back to the same attorney, such as myself, I have a Word version of your trust, and I might do just one change, but I would do an amended and restated, just because it's easier than having to pull out multiple amendments and seeing what's this paragraph now. So whenever you do a simple amendment, you're going to have to hold on to all prior versions, and you're going to keep them all together. Whenever you do an amended and restated, you shred the old ones because we don't need them anymore. We just look at the newest copy. That's a simple way to think of it.
Can I ever just break down the whole trust ecosystem? Could they ever outlive their usefulness? Can I dissolve everything? Can I change course entirely back if I prefer probate, or the law, encourages me to go back to the kind of the pre-trust world?
Yeah, you can. It's rare because revocable trusts are so flexible. We can change the trust to say anything we need it to say. In fact, if we change the trust terms, we still keep the same name. So if you own property in that trust, you don't need to retitle it every time you change the trust. But that said, there are some instances when we would revoke a trust. For instance, you just don't like the complexity. The document's too long. You want something simpler. We can revoke the trust and switch you back over to a will. That's pretty easy to do. We'd have to take assets that are titled in the trust out of it into your own name again, but just a simple deed or change of ownership, and it can definitely be done.
That's fantastic. Thank you very much. If somebody has heard something that they found very important, or they just want to ask you a question, what is the best way for them to reach out and to engage you, Clinton, to get more information?
Yeah, so if people want to contact me directly, like I said, my law firm name is Schaefer Thomas Mays. S is in Sam, T is in Tom, M is in Mary. You can find us at stmlawfirm.com. Phone number 303-469-7367. And my email is on the website. You can find me at ccarlisle, CCARLISLE, at stmlawfirm.com. Feel free to call anytime. Usually we will have a quick intro call with you just to talk about your situation, tell you what our process is like and what expected fees might be. And then we'd have you in the office to look over your existing plan, talk about what options you have for going forward, and design a plan just for you. So it's a long process that you would get to know me pretty well. It takes several weeks for us to know everything about you, talk to your advisors, and create your plan. I'd love to talk with you anytime. Feel free to give me a call. I think the number will be in the description below also.
Clinton, thank you very much for your time. This has been the fourth in a four-part series that we've partnered with Clinton at Schaefer Thomas Mays to provide great analysis and insight on what you can expect from establishing a good, properly maintained trust. If you haven't, go back and watch the other three parts of this series where we discuss the basics, the pitfalls and possibilities of probate, as well as some of the tax benefits that happen from having a properly maintained trust. It's been fantastic having this partnership with Schaefer Thomas Mays, and we're happy to move forward with Clint and Carlisle. Thank you very much again for your time. This has been a production of NearSight and FarSight from your investment professionals here at InSight.